Hello, and thank you for joining us for the next SLW Institute webinar, Patent Protection at the Intersection of Life Science and Computer Science. A recording of the webinar and the slides will be made available to all registrants. I will put a link into the chat with a link to the slides. They are posted on our website. Feel free to enter any questions using the Q&A feature in the Zoom menu. We invite you to follow us on LinkedIn to see news about other upcoming webinars. And with that, I'll turn things over to Trevor and Leah.
Thank you, Michelle. Thanks everyone for joining us today. My name is Trevor Lind, and I'm a patent attorney here at SLW. I'm glad to be presenting with my colleague, Leah Westman, on the topic of patent prosecution at the intersection of life science and computer science. This is an area we've gained a lot of insights and experience in, and hopefully the information we share today will be helpful to you. We really did try to make it practical. We're going to keep our cameras on for the introduction, but then we'll go ahead and turn them off. I'll give you a little bit of my background. I've been practicing patent law for about 20 years. My technical background is in chemical engineering with a focus on biochemical and bioprocess biomanufacturing. As a patent attorney for my first 10 years, all I did though was software and hardware cases. And I did very little in the life science or chemical space. And then after about those 10 years, I got the opportunity to practice sometimes full-time, sometimes part-time in the life sciences, and would supplement that with computer science. But then over the past 7 years or so, I've started to, well, 7 years ago, I started to get some experience working on applications in this crossover space between computer science and life science, and it's just sort of increased over that time. So we'll just be taking some of our, the knowledge that we've gained and insights over that time and be sharing that with you today. And I'll hand it off to Leah.
Thanks, Trevor. It's always odd seeing your face on the screen like that. But anyway, thank you again for joining us. We're going to have a great discussion today. I have been practicing for about 8 years in patent law, and kind of a similar vibe to Trevor. I spent a lot of that time doing kind of device work and a little bit of software, but my background is actually biochem. And so I think similarly, I've ended up doing a little bit more work over the years in kind of that weird intersection where different disciplines interact, and specifically where software overlaps with both chemical and life sciences. So we know this area is a really emerging area in patent law, and thought it would be worth having a good discussion today as we all try to navigate some of the issues that arise in this. So with that, we'll jump in. Michelle, if you could, yeah, there we go. Got the deck moving forward. Today we're going to start just by going kind of over the landscape of what we're referring to as bioinformatics, but really any kinds of cases that may end up at this intersection of life sciences and software, of which there are quite an increasing amount as software becomes more pervasive in all technology areas. And after we kind of get an idea on how this area is growing, we'll talk about some frameworks we're using to look at these cases and to organize them and to hopefully be successful in helping prepare and prosecute patents in these areas. So we'll look at this both from a scientific framework and the kind of work that's being done in the area, and from a legal framework and answering questions about what we may need to do for patentability in different areas. And as Trevor noted, we're definitely going to dive into some hopefully helpful practical discussion about what to do in this area. We go to the next slide. We'll jump into an overview here. So I suppose the first question we'd ask is, what is bioinformatics and what do we mean about the intersection of software and biotech? Well, a lot of what we're discussing today is going to be in the middle of this Venn diagram. So oftentimes, patent attorneys in particular tend to stay in their own lane, right? They'll say, oh, I'm an electrical guy. Oh, I only do chemical cases. But what we're seeing is more and more kind of the edges of things bleeding together. So in a lot of the cases that Trevor and myself have worked on, we'll see software aspects, right? So methods that are driven by a computer, algorithms of different kinds, digital data, but we'll also see something that's what we would call in the real world, if you will, what is referred to as wet lab processes, meaning that people are maybe collecting samples, right? So maybe you're collecting COVID tests and collecting, a blood sample or something and extracting biological data from there. And the physical methods by which you're using that to get biological data, in addition to the analysis of that data, can all kind of fall under this umbrella of this intersection of software and life sciences. So if we go to the next slide, the kinds of cases we're seeing are really all over the place. And we're seeing software and machine learning creep into all different areas. So for example, you may see cases like genetic data collection, 3D shape analysis, such as of proteins, drug discovery using AI. There's a whole host of things on here, and this is by no means an exhaustive list of the kind of cases that may fall into this area. We can go to the next slide here. So what is bioinformatics specifically? So you'll hear us use the term bioinformatics a lot. What we mean by that is it's combining biology, computer science, and statistics in the analysis of biological data. And as you can imagine, that is right at the intersection of software and life science. And those are exactly the kind of cases we're discussing today. However, we should be careful because bioinformatics doesn't necessarily cover everything we're talking about. Other related areas can include computational biology, computational genomics, computer-aided drug design, and a whole host of other types of cases at this intersection. We can go to the next slide. All right, so what kind of filings are we seeing? You'll see just generally that applications in this area have continued to grow over the last 20 years. And while we were seeing maybe about 20 years ago, we were seeing maybe 400-ish cases in this area. In the last handful of years, we're seeing more than 1,000 a year in this area. And I'm not sure when our 2023 data was updated, but in general, it appears that the trend is going up, and we'll continue to see more filings in this intersection of these sciences. If we could go to the next.
Hey, Leah, before Michelle, could I mention
go ahead,
something
Trevor.
real fast? One thing I thought was interesting. Oh, so one thing about this slide is that so the number of issued patents that you see is not the number issued that year, but the number of patents that were filed in that year that were granted. So like for 2008, that's the number of patents filed in 2008 that were ultimately granted. That's why the numbers go down to 2022 and 2023 and 20 before that. But one thing I thought was interesting is that the we'll talk a lot about 101 and how strategies around that, but I think it's just interesting to note that the percentage of cases issuing from a given year is pretty close to the same going back, from where we have these statistics. So I just thought that was interesting that even with, 101 and dealing with some of those issues, the number of allowances in the cases filed in a given year is pretty consistent over a pretty long period of time.
Yeah, that's a great point, Trevor. It's always interesting in this area that's ever evolving to see some things stay consistent and some things adjust. So here, we're looking at the life cycle of some of these. And you'll see not only do we look at the number of applications per year, but also the number of assignees. And you'll see there has been some growth in assignees in this tech areas in the last few years, but it has not kept pace with the number of applications. It seems like the ratio of assignees to applications has has altered a bit, meaning the same companies are maybe filing more in this area. I don't know, Trevor, if you have other thoughts on this one as well.
No, that's good.
Okay. On that note, we'll move on to the next slide.
Yeah.
So I take it away, Trevor.
Thanks. So yeah, so I told Leah when we were getting ready for this, I felt like, oh, we could just tell war stories for an hour about different things we learn through the examination process, but we will not do that. We'll sort of work through, you know, some, like I said, some more practicals. But in this part, what we want to cover is, you know, just sort of looking at where the application ends up in the USPTO does have a bearing on how things can go and the different you know, strategies that you can use. I've seen certain things be successful in TC 3600 that aren't necessarily successful in 1600. There is some crossover. So that, you know, it just can be, sometimes it's hard to know where your application will end up, but where it ends up can have a bearing on how you proceed. So if you could go to the next slide, Michelle. So we kind of took a sampling of where are we seeing our applications in this space, like what art units are they found in? And you can see here there's many different technology centers from 1600 to 2600, 3600. We'll dive into 1600 and 3600 a little bit more. That's where we tend to see the majority of them, but we've seen them in all of these art units. The TC 2800, I know that looks a little weird seeing semiconductors, but there is a measuring and testing part of that. And so when you sort of dig down into the different specific art units in 2800, there are some that are more along the lines of like computer science with related to like analytical testing and measurement devices. So can you go to the next slide, please? Oh, go ahead, Leah.
Actually, can I just add, it fascinates me that all of these different technology centers we're seeing for some of these applications, there doesn't seem to be yet a really central location where you're getting the same TC and the same examiners for bioinformatics cases. They're really all over the place, and it very much depends on your claim set, on the very specifics of the application. And as Trevor will dive into, it definitely changes the examination process. So
yeah, and it can be frustrating sort of trying to navigate all of these different, you know, because everyone has the examiners in the different art units kind of have a different framework for looking at these. And so, yeah, so we've tried to develop strategies where we can sort of see things through in generally all these areas. So next slide, please. So here's TC 1600, just kind of a breakdown of the subject matter that's in the different groups and the 3-year grant rate. I will say about the 3-year grant rate, I mean, I feel like when I looked a little bit farther along, like 4 and 5 years, the grant rates did go up. I think that's because it's just taking a while to have some of these applications examined. And I think 3 years probably isn't enough to capture them. But a lot of the cases we're seeing are in 1630. Sometimes I'll see some in 1620. And then it's so funny, you know, down here 1670, it says unknown new group. I probably about a year and this is just from like the software that we use to pull these statistics that came up like that. About a year and a half ago, I was talking to an examiner because my case that I was working on had been transferred to a different examiner, and I called the previous examiner and just tried to find out why and if maybe he could have it transferred back to him because we had made a lot of good progress. But he was telling me that there was a sort of a new group that they were trying to establish within the PTO that had an emphasis on computational technologies in the life sciences, so that people who either had that technical background or who were willing to sort of learn and work in that space were going to be a part of that new group, and that patent applications would be assigned to that. So that's what unknown new group is. And Michelle, if you could go to the next slide, please. So this just kind of breaks down a little bit more of, you know, the art, what's in that art unit, and the 3-year grant rate. My understanding, you know, when I talked to the examiner about a year and a half ago about this initially, was that, I don't think it's been around for 3 years. So, but I think this is just for applications that were filed 3 years ago. But you can see the allowance rates are pretty close to what they are in the other parts of TC 1600 that are examining these types of cases. I will say that I had one case where, so one thing that I think we've seen happen a couple times is that examiners, they're actually very upfront and very honest. They'll say, I don't necessarily understand this computational technology. I need help. Will you please walk through this with me and help me to understand it? And they're really smart, and they tend to pick it up. And I think they're appreciative of that. We've seen some success in being able to secure allowances in cases where maybe the examiners don't necessarily feel comfortable at first, but then once they're comfortable with the technology, they feel good going forward. But there was one case that I'm working on where we had a restriction requirement and they're asking for a species election. And I called the examiner and I said, no, this isn't, we're not, electing compounds or anything along those lines. This is a computational case. And she said, I'm not necessarily super familiar with this. And so I said, well, what if I amend the claims to make it super clear that this is a computational case, and would you see if it's possible to maybe transfer it into another art unit? And I was thinking of the 1670. I had that in mind, and I wasn't sure how it was going to go, but they actually did. So I was really glad to be able to see that, and I think the examiner was too, because they don't have to sort of deal with this computational technology, and it's going to an examiner that's a little more familiar with it. So can you go to the next slide, please? So here's 3600. So, and 3600 covers all kinds of things. So, but at 3620 and 3680 are the places where we tend to see this sort of overlap technology space, have those applications assigned. You can see that the 3-year grant rate is really low. And I feel like anecdotally it's higher than that just because of cases that we've worked on. But I think part of the low grant rate in these groups is just because they're sort of grouped in with coupons and incentive programs and those sorts of things that have pretty low allowance rates and have a lot harder time sort of working through especially the Alice framework. But 3600, I feel like it's higher from what we've seen before. And next slide, please. So, but if you're assigned an examiner in Art Unit 2025, the allowance rate is 77%, which we've seen. And it's really interesting. And I think one of the main takeaways is if it's a database, data structure, high performance computing case, it's just helpful to draft the application and the claims that are directed to those inventive aspects. I think sometimes we'll see cases where there's a lot of template material and there's a tendency to maybe want to put some of the life science aspects in the claims initially. I think if you're forced to do that later on, that's sort of another discussion. But I think initially to be able to focus on the more computer science parts helps them to be slotted more of where the examiners are comfortable examining the technology. And so, so yes, if you have a database, you're analyzing different kinds of structured, unstructured data, that sort of thing. And if you find yourself in Art Unit 2125, you can have a really nice allowance rate. And I've seen claims in this art unit be pretty broad, much broader than something that I would expect in 1600. And so it can be a faster examination process as well. So that's just, we'll talk more about drafting later, but one of the drafting takeaways is if you have, if we've got the computer science side of the application, to focus on that within the claims itself and not bring in a lot of template material, that kind of thing. Next slide, please. So we're going to talk a little bit frameworks for drafting and prosecution. And could you go to the next slide, please? So to just kind of help organize our discussion going forward, sometimes where you are in the scientific framework dictates how to proceed legally. And we'll draw these distinctions as we go through the presentation. In the scientific framework, we sort of have like, there's a manifestation of a biological condition, whether it's a, biochemical process is being disrupted or somebody has a disease. And, if you're able to figure out what that is that's going on, there's usually a sample that's collected. And, it could be through imaging, it could be through a blood draw, that sort of thing. And then there's a lot of data that's generated, sometimes huge amounts of data that are generated in that, using that sample. And so then we move into the data analysis part where those large amounts of data are being analyzed. So a lot of times we'll see the life science types of considerations that we'll be talking about are in the sample collection and data generation part, but then the computer science are more in the data analysis part. And so we'll just kind of go through and tie in the legal framework and where, and the drafting considerations with respect to where the innovation is taking place within the scientific framework. And so Leah will talk about the legal framework next.
Great, thanks, Trevor. So as Trevor said, there's a certain scientific framework we have in mind when we're looking at these cases, but we're patent attorneys. We're also looking at the legal framework on, okay, how do we draft these cases well and prosecute them so that we can help get our clients patent protection. And there are, as most of you know, a few different things we need to look at, which under the category of 112 in this area, because we do have kind of a life science aspect, we have to discuss what's a predictable art versus what's an unpredictable art. And that can lead for some interesting considerations unique to this intersection. We have, of course, a very fun discussion of 101 and patentable subject matter, whether or not both you have on the software side and on the life science side, what may be eligible or ineligible under 101 and how to hedge against that. And then, of course, we have considerations of novelty and inventiveness. And, in that area, we'll talk a little bit about some considerations that may involve divided infringement and other issues. So we'll use these 3 points to kind of structure the rest of our discussion here. And we'll actually turn first to kind of some 112 considerations, written description, enablement, and considerations under 112 that are unique to patent prep and pros in this area. If we could go to the next slide. So first things, Trevor did a great job of outlining kind of the scientific framework here, which we have recapped on the right for you. But one of the very unique things about this area is that computer science, right, it's interpreted as being predictable, a predictable art, whereas life science and the chemical arts are generally interpreted as being unpredictable, right? And there's quite a bit of case law that supports those two conclusions. So when you have a case that involves both computer science and life science, you run into some unique issues because you're trying to thread the needle between two very different styles of patent practice, being that maybe half the case is what would be called a predictable art and half the case is an unpredictable art. So if we could go to the next slide. Many of you are familiar with this case, which speaks a little bit to this concept of predictable versus unpredictable arts and enablement of a patent at the intersection of life science and computer science. This Amgen versus Sanofi case is infamous now amongst a lot of us that practice in the area. And in this case, Amgen's patent recited a really broad, what we would call genus claim, meaning they claimed an entire genus of antibodies in the claim that could have these behaviors. So any antibody that in the genus that could bind to a specific amino acid residues on PCSK9 and also block PCSK9 from binding to LDL receptors. So that was the initial claim that was invalidated in this case. If we could go to the next slide. Now, the reason that the court invalidated this claim, kind of under an enablement framework, is that a broad genus claim like this would require an artisan to do a large amount of experimentation to get to each species that would fit this claim. And it would ultimately be undue experimentation. So really this plays into the idea that in life sciences, this is more of an unpredictable art. And in this case, the genus claim was not fully enabled unless every species under that genus was described in the patent. Or the other way that the court said the claim could potentially have been valid is if the genus described sufficient structural detail as opposed to the functional detail that was in the claim. Trevor, do you have anything to add on Amgen before we move forward?
No, I think we've got it on the next slide.
Okay, so at the end of the day, the unpredictability of the art here was really a factor in the court's decision. Okay, so the court said that, regardless of advances in the technology area, there's quite a bit of this particular art area of antibody science that is unpredictable. And scientists can't always predict, how trading an amino acid would affect an antibody structure and function. So at this point, it would cause, undue experimentation in order to fully enable the claim. It is kind of funny, their last little quote here we have underlined the court said it's going to get a Nobel Prize for somebody at some point, but translating that sequence into known three-dimensional structure is still not possible. So unfortunate for Amgen and their claim here, but makes us think a little bit about what practical considerations we have in claim drafting in this art area regarding enablement. If we could go to the next slide, please. So what are some kind of takeaways from Amgen, right? We really need carefully crafted claims. You want to try to focus claims that cover a core use of the invention or core embodiments. And, I think that's true in a lot of art areas, and particularly here, we may want to also consider claiming computational aspects separately from life science aspects, if possible. I think, Trevor, you had a little caveat you wanted to add here regarding 101 as well.
Yes, just that sometimes being able to have, if you have a computational claim, if you have a tie-in on the life science side, it can help move the case forward. But then you might have a divided infringement issue. So there's a lot of sort of caveats to all of this. I've seen examiners suggest adding in a physical tie-in, especially in TC 3600, to be able to help move the cases forward. But in 1600, that may or not be helpful.
Yeah, and it really is interesting because I think if you're trained strictly in drafting software patents, you already kind of understand this next point, which is any computational aspects you may want to be drafting from the point of view of the computer performing the operations. But that's almost counterintuitive to someone who was maybe trained in drafting cases in the life sciences or chemical arts. But I think that does help kind of puts a little bit of guardrails sometimes as needed. So if we go to the next slide.
I think that, can I jump in just real fast?
Yeah, go ahead.
I think that's true. And I think that it helps. Sometimes some life science oriented cases can be very research paper like and are often based on research papers. And sometimes the computational techniques are just sort of referenced, and there isn't detail around what's going on, but sort of behind the scenes. And I think it can be really helpful to have that behind the scenes description, especially when you're dealing with 112 and 101.
Yeah, and I think that's huge. It's often, right now in particular, most of us that end up drafting cases in this area, we're trained on one or the other, right? We all first learned software or we first learned life sciences, and it's really easy to get just kind of tunnel vision into the mindset of one or the other. And I think, if you are starting from a life science perspective and you have that kind of almost research paper approach, as Trevor was saying, you're great at all the things that are on this slide, right? Providing deep examples, life science features, but it's just as important to provide the structure that you need for the computational side. of the application. And a lot of that has to do with claim structure, and we'll get a little bit more into that later with some of the novelty inventiveness discussion too. But yeah, it's a balancing act. So for those of you that are from the more software side of things originally, here are some other drafting considerations from the life science perspective, which is you really do need to provide examples. And you know, capital E examples are something that's very prevalent in life sciences and the chemical arts. I was taught back in the day that they're supposed to almost read like a lab report sometimes, right? But it's a lot of the enablement and showing proof of concept in some respects that you can actually practice this invention. And so to show that, you need details of components used, process steps, architecture of experiments, analyses, techniques that were used, all these kinds of things to fully enable that. So, you know, if you start writing cases in this area, you not only now have to check all the boxes for a software case, but also a life science case. Lots to think about. So we'll move on to the next slide here. And this is a more kind of visceral approach to saying you have to include both the software side and the life science side. Some things, as we just discussed, in biotech and chemical cases, we rely on examples, we rely on data, and that should be in there. Whereas a lot of times in software practices, you'll get a lot of flow charts, a lot of discussion of logic and other figures. The best bioinformatics cases have both in a nice balance to fully support the case. All right, I think with that, we're on to 101. So Trevor, all you.
Thanks. I want to add one quick thing back on 112 on the flow charts. I know that there's a lot of like life science and chemical oriented cases. Sometimes there aren't any flow diagrams and there aren't any sort of like software architecture diagrams. It's sometimes no drawings. I've seen that. And then there's times when it's, you know, just sort of showing experimental data, but it can be really, I have found it really helpful to include flow diagrams and computer architecture diagrams in these crossover cases to help me organize my thoughts in the subject matter and just sort of the flow of how the technology is being developed and how, you know, where the data is coming from and how it's being processed and that sort of thing. It can be really, really helpful. And it helps to provide good support for claim amendments later on. Let's see, could you go to the next slide, please, Michelle? Thanks. So, so the 101 framework, you know, so this can be really, you know, it can be challenging sometimes for us to be able to work through 101. It can be frustrating. It's hard when the examiners apply things differently. We're going to try to go through strategies that are helpful across the board. Some strategies work for some examiners and some work for others. Some on the drafting side, I think we'll find that it can also help internationally when you're doing international prosecution. But we'll start just by going through, you know, just a couple of cases to sort of help illustrate this. So this slide talks about, you know, Alice, Mayo, or both, because, you know, in bioinformatics, computational cases, you tend to have, you know, abstract idea rejections, and on the, if you're doing diagnostic methods and on the life science side of things, you can see Mayo-oriented rejections and natural phenomenon. So we're going to go through that and take a look at those. And interestingly, can you go to the next slide, please? 23andMe versus Ancestry. This was a case that was a little while ago, but I always felt like it was very interesting because it, in this case, Ancestry alleged that the claims were both natural phenomena and abstract idea. The court didn't go down that, didn't choose both of them to analyze it through. It picked one, but it's basically, it was, the algorithm was around determining whether or not two individuals are related and how you do that. And you look at DNA information in these identical by descent regions. Next slide, please. So Ancestry said, you know, part of this is an abstract idea. You're determining a relationship between relatives. You compare DNA similarities, and then you have this biological part, it's a law of nature, people who share similar DNA are related. So that's just a natural phenomenon. And next slide, please. So the court sided with ancestry, and they decided to proceed under Mayo. They said that it's determining whether two individuals are related is more focused on the life science side of things, and it's more of a natural phenomenon rather than an abstract idea and the computational side. They found that it's too close to the intrinsic nature of DNA. The IBD analysis relied on used well-established concepts, and so they found that it wasn't eligible. It wasn't patent eligible subject matter. Can you go to the next slide, please? So, oh wait, can you go back? Sorry, I had one more thing to say. So with for 23andMe, I feel like what was really interesting about this case is even though, so at the district court level, the court found that it was to proceed under Mayo and to make its 101 determination under that. The Federal Circuit, when they got this case, they actually didn't publish an opinion. They just had a Rule 36 affirmation. But you could go and listen to the oral arguments. And I felt like going back and listening to those was very interesting to just hear the confusion between, are we doing natural phenomena? Are we doing abstract idea? The language is all getting mixed up. It was just really, I think, challenging for them to sort of grapple with all of this. And it seemed like there is a lot of confusion there, but ultimately they decided to uphold the district court's decision and find not patent eligible under Mayo. Okay, next slide, please. And so Ariosa, yes. So I think we feel like we're very familiar with Ariosa versus Sequinome. This is again a natural phenomena that was invalid under 101, where we're trying to amplify the DNA to determine if it's from it's the baby or the mom. They found that the amplifying and detecting steps were conventional and routine in the art. So they found that it was not eligible. It was invalid under 101. Next slide, please. And then, so we just see some of the language here, how, the method begins and ends with a natural phenomenon. It's not new and useful. I think what's really hard is, it was just, they felt like it was well understood, routine and conventional. I feel like that's a, just a theme that we see in a lot of these, especially the court cases that make it through. Even in 23andMe case, I remember I went back and I looked at the claims, and I felt like some of the dependent claims had some, pretty good detail around how you might be able to determine whether someone's related, but those were never argued. So I think, and on the drafting side, it can be really helpful just to have details on how things are being done. Next slide, please. So the next case is Stanford, and this was a case that went to the PTAB. They found the claims not to be patent eligible, and they appealed to the Federal Circuit. So the interesting thing about this, and we'll talk about it later as we talk about 101 a little bit more, is that the application does describe that there are improvements to a technology field. It talks about how in the prior art you have an incomplete number of allele haplotypes. The claim methods increase the number of possible haplotype phase predictions. So it talked about how there's these different advantages that come from performing this method. I think one of the things that was really hard about this case is that most of the operations were receiving or providing, and I feel like under a 101 analysis, the examiners in the court, they just sort of throw those out. And so there were two main determining steps, and one of them was they found was conventional and in the prior art. And it's really interesting because the specification, and this goes a little bit back up to what Leah mentioned with 112, the specification talks about, oh, there was this previous technique that was performed, it's conventional in the art, and you were able to determine this particular feature using that technique. And that's so common to be able to see that in life science oriented cases because you're wanting to make sure you satisfy the enablement requirement. You want to say, yes, this can be done, people can do this, but they included that in the claim. And so then the court was able to say, well, you said that this claimed feature is already known in the art, so that's conventional. And so it really came down to one operation that was determining a haplotype phase for one member of the family based on certain kinds of data. And two of those kinds of data had never been used before. And so that's where the novelty was, but that's all that it said, is determining a haplotype phase for at least one member of a family based on these kinds of data, and lists 4 different kinds of data. And the court just said there's not enough here. Can you go to the next slide, please? So the Federal Circuit held that the claimed advance that Stanford has does yield. It does have this advantage, and it may be a new or different use of a mathematical process, but they said that it's not an improved technological process. They also said that the written description makes clear that the mathematical steps and the types of data received are conventional and well understood in the prior art. And when I really looked at the application, this patent family, there is another issued patent in this family that has a lot more detail behind this. And I feel like the claims were great to assert because they were so broad, but I think they just had a really hard time, when they had the scrutiny under litigation to be able to make it under 101. Could you go to the next slide, please? And then, I felt like this is interesting in the holding as well. The Federal Circuit cautioned against simply adding a diagnosis or treatment step. So some of the dependent claims talked about, you're using this technique to do a diagnosis, you're using it to provide treatment, but they said without further limitations, these claims do nothing more than recite the haplotype phase algorithm and instruct apply it as the Supreme Court has prohibited. And they reference Vanda saying, you're not saying what the dosage needs to be. There's no parameters on how this drug is being administered. And so this doesn't help us to be able to move out of an abstract idea. And I think it's a little bit of a caution. I know in diagnostics cases, some examiners, not all of them, but some of them will help move the claims forward if you put a treatment step in there. And I think it's just making sure when we're drafting to have some description around what that treatment might look like, why, and dosage requirements and that sort of thing, I think can be really helpful to maybe counter these types of arguments and statements like we saw in the Stanford case. Next slide, please. So we're going to talk about some, common 101, just rejections that we've seen, arguments that we feel like have been helpful because we've seen allowances come from some of these, and also some drafting considerations. So next slide, please. So the first we'll talk about is a mental process rejection. So the MPEP talks about, the claims do not recite a mental process when the limitations can't practically be performed in the human mind. I have had examiners, cite this, and it can be frustrating sometimes because you're thinking, this is such a complicated process. This is machine learning. There's all these things going on. We're analyzing thousands, if not millions, of sequences, and there's just all of this that's going on. How can this not be complex? And in arguments, I've cited articles, I've provided evidence, done all sorts of things. And I think what I've just decided what I've been doing is just adding in, adding in the application when we're drafting it, elements that are related to the complexity of the inventive concepts, and talking about the number of sequences analyzed, the amount of data that's stored, the number of iterations in the training process, and just showing how big this is. Go ahead, Leah.
Trevor, if I might interject here, I like this approach, having in the spec kind of the volume or the complexity of the process, because I think oftentimes we'll get back on a first office action, oh, you could do this in the human mind, it's a mental process. And, as the attorney looking at it, we're going, no, you can't. What kind of mind do you have? And I know that just making amendments that specify just how big of a process this might be and can help clarify, not just in a 101 issue, but maybe can also help later on with some of the inventiveness in the 101, 102 or 103 issues, where you have questions of art that's being cited might be, for instance, looking at one small example of a genetic sequence that is very short, very much short enough that you might be able to do with a paper and a pencil, right? As opposed to thousands of SNPs or other analyses, right? So I know we promised we wouldn't tell war stories all presentation, but I'll let you continue.
Yeah, thank you. No, it's true, and it can be tough. And I mean, I when we're doing the drafting, we try to figure out what's sort of the lowest number of sequences you might look at, and if we need to put something in the claims, it's clear that whomever is performing the algorithm would need to use at least that many. And if we need to put that in the claims, which some examiners ask for, it's just a very reasonable element to put into the claims without narrowing the claim really very much. Next slide, please. So the mathematical concepts rejection, I feel like I definitely see probably more often than the mental process steps, or at least that one tends to be the stickier one, the harder one to be able to work through. And so, a claim does not recite a mathematical concept if it's based on or involves a mathematical concept. So one thing is, trying to not necessarily put, equations in claims can be helpful, because then that's just sort of a red flag for the examiners to be able to look at. But I've seen some really broad claims that have equations in them. It's just they also end up being very narrow. So we try to be able to avoid that for multiple reasons. And the mathematical concepts is one of them. But to me, part of what's frustrating is I'll submit arguments around example 39 of the subject matter eligibility examples, which is very helpful sometimes. I've seen examiners say, yes, I understand, and they move the case forward, and the 101 rejection is gone. But the language in 39 talks about, the claim does not recite any mathematical relationships, formulas, or calculations. While some of the limitations may be based on mathematical concepts, the mathematical concepts are not recited in the claims. And so that's sort of the reason to keep the equations out, and to try and avoid language that sounds like math, like sum and average and those sorts of things. I think those are also red flags that the examiners can key in on. So I've seen the arguments based on example 39 work and sort of using this same language, but I had an examiner a couple months ago in an interview say, well, those are just, that's just guidance, and it's not necessarily the law. And so they just kind of dismissed my argument, which was frustrating. So I had to come up with other ways forward. Next slide, please. So you can also focus on a practical application, and this is where this sort of lists some of the different kinds of practical applications that there are. The one that I try to tend to focus on is this idea of improvement in the functioning of a computer, or an improvement or other technology or technical field. In these cases, I think really try to work with the inventors to figure out, what are you doing that can be helpful to use less data to be able to make this process run faster? How sometimes the biology drives the computational architecture, and how does that provide improvements? Why are you using the data that you're doing? How are you processing the data, and how does that improve your results? And so trying to be able to draw these things out, I feel like can be helpful in moving forward and helping cases move forward with respect to 101. Next slide, please. Next slide, please. Okay, thanks. And so then natural phenomena rejection, and sometimes abstract idea rejection, this is what we talked about a little bit earlier, putting a particular treatment in for disease or medical condition. And I think it's important to include those. It is just important also to make sure that the Vander requirements are met, if at all possible, if there's the possibility of relying on that to be able to help overcome the 101 rejection. Next slide, please. So here's some, just with abstract idea rejections, here's some different things, different considerations. So you argue features that cause an improvement of the functioning of a computer, make sure those are in the specification. It's possible to, I've seen 132 declarations to include this kind of material in there. That's another thing. In TC 3600, they don't know what to do with that, but in TC 1600, they feel a lot more comfortable, and that can be helpful. Here's some cases that help with that. Enfish and McCrow are persuasive when you have improvements, and those are persuasive under 2A, the step 2A of the analysis. 2B was Alice. You can discuss features that improve. Oh, I talked about that in the specification. And I do think it's really important, though, to connect the claim features to the improvement. So if you're getting an improvement in the functioning of the computer, it's really helpful to have that feature in the claim to be able to tie back and say, because I'm doing this in my claim, you're getting this specific technical improvement. I do think that it can be helpful to include data in the application that shows improvements, even if it's computer science and technical oriented. Like Leah mentioned earlier, this isn't something that we're used to when we do it on the computer science side, but I really like if I have some bar charts or diagrams that the inventors have run a conventional process alongside theirs, and they show that they're getting improvements over it. I really like to be able to have that in there so that I can point to that during prosecution. And then, yeah, the improvements might not be successful if you don't tie to the specific claim operations. And then improvements may not be enough without more. Both 23andMe and Stanford, there were improvements, but there just needed to be more substance to the claims, I think, in order to be able to help them get closer to patent eligibility. Next slide, please. So other drafting and prosecution considerations are, what parts of the technology pipeline are unconventional? I've actually seen this happen more often. I've seen cases move forward when this unconventional argument is made. And I think it's helpful to include some cases along these lines are unconventional plus improvement, or AMDOCs. Unconventional combination of features as a whole is BASCOM. I think that can be really helpful, moving the cases forward and pointing out that this element of the claims isn't being done in conventional technologies, therefore it's not conventional. And if you can even tie that to an improvement, that's better. And I do think that it's important to be careful in the specification what you characterize as conventional or typical, just to make sure that it's not part of the inventive process, and you might not want to put it in the claims. Next slide, please. So I think we've gone through a lot of these. Technical problem approach from the European practice can be helpful. I think it's important to draft robust specifications and try to incorporate as many strategies as possible to help overcome the 101 rejections. And then based on McCrow, if you have rules or frameworks that are being used, we want to include those in the specification as well. Next slide, please.
So real quick,
over.
I was going to say real quickly before we finish up, there were a few other considerations we had with novelty and obviousness. If you could go to the next slide, please. So drafting considerations, again, we're looking at this scientific framework on the right. It's helpful to identify where the novelty is within this framework, right? Is it during the sample collection? Is it during the data generation? Is it during data processing, the computation steps, or is it the output itself? And figuring out where the novelty is can really help you in structuring the application and being prepared for prosecution down the road. It's also helpful to think on how the biology impacts the computational architecture, that is, how the life science part of it interacts with the computer science part of it. So they're not two distinct things. And finally, it's nice to consider what type of data is going to be analyzed, processed, pre-processed, or used in computational techniques. Having these questions in mind at the beginning when you're drafting can really help you shape a good full application, and will also kind of pave the way for you to say, okay, I do need flowcharts here, or I do need examples here, or I would like data here to support these ideas. If you could go to the next slide, please. Now, we mentioned this earlier. One of the things you'll find in this art area is divided infringement can happen if you're not careful with your claims. So you may want to think about who is the intended infringer here. This is particularly pertinent when you have a case that really has both physical steps in a laboratory and software processes. And you need to consider whether you want claims to include both or you want claims to each, and really have a broader mind of, is it going to be the same company infringing all those aspects? For instance, if you have steps that occur in a laboratory processing biological samples, maybe a different infringer than the person analyzing the data that comes out of those samples. So something to think about. And if we'll go to the next slide. One last consideration here under novelty and obviousness. Trevor mentioned briefly the use of declarations or affidavits in response to 101 rejections. They also, as those of you in the life sciences know, can be helpful for 103 rejections, for obviousness type rejections, to help bolster the data you have, and can include things like scientific data, expert statements, commercial success, inoperability of the prior art, and a number of other things. That said, declarations are not the first choice in prosecution, but if you need them, you can maybe use them as a multifunctional tool with obviousness rejections, subject matter eligibility rejections, and sometimes even enablement rejections. But there are pluses and minuses to using them, but good to think of sometimes in this art area. So I think
Can I add something there?
Oh, yeah, go ahead. I was going to say.
So like for the 132 declarations, it's really interesting. I saw this one case that was allowed recently that had what they used was it was almost like the 103, 102 rejection was a foil that within the 132 declaration that they were able to use to discuss the how it was not conventional, and that sort of bled over into the 101 and helped to be able to overcome both the 102, 103, and the 101 rejection by sort of contrasting the claim features with what was conventional in the prior art. And the inventor, they just did a really nice job of talking about how it was different, and because it was different, it sort of overcame, just a whole gambit of rejections.
Okay. Well, I think that's all we have prepared. So we've got 2 minutes for questions, I suppose. I think I saw one come into the chat here. Michelle, did you? So I see the question I'm seeing, Trevor, is someone said, I see claims that only the doctor could infringe. Any value in those? Realistically, has anyone sued a physician over a patent? Yeah. Trevor, what are your thoughts?
Yeah, I feel like that's a great point. It's true. That's why, sometimes adding in some of these steps at the end isn't always the best. It can be maybe a last resort if you really need to if it's important to have patent protection, but enforcing it would be hard. And even if you're doing sample collection, if it's a patient who's collecting the sample and who's maybe using your device, are you really going to sue your customers basically to, for infringement along these sides? Yeah, it's a great point.
Yeah, I think there's a lot of considerations in claim drafting. So, and things to think on. But I think we're just about at time. So unless anyone has last minute questions, we'll let you all go. But, thank you again so much for joining us. We really appreciate it. And, let us know if you have other questions afterwards.
Thank you.